All right, everyone, welcome to week 9. This week is quite a large topic looking at both the United Nations and the use of force. In the reading this week, much of the readings is just focused on the use of force, and so I'll just provide a bit of an overview of the United Nations here. We don't need to know anything in huge amounts of detail, and we've already gone through quite a bit of the United Nations founding documents and other important documents associated with the organization. And I'll also talk more broadly about like international organizations and their place in international law before we get into the use of force. Also this week, hopefully coming quite soon, I'll be releasing a video relating to the moot or the third assessment task, just giving you some tips for doing a moot if you haven't done one before, and also maybe some points around structuring your written submissions. So look out for that. I'll also direct everyone to that in the tutorial as well. So let's get started on this quite extensive topic. Let's just make sure the slides are working. All right, so this is what we're doing today. So it's quite a lot looking at international organizations and then contextualizing that discussion by focusing on the United Nations. There's obviously many other international organizations, but the United Nations is kind of the premier one. And then we look at the use of force. So look at the prohibition of the use of force, exceptions, and then also where the use of force has been justified. And we're going to consider these rules more critically as well. So let's start with international organizations. And again, we're examining probably the most important one of them, the United Nations. So we'll have a look at the role, function of the United Nations, its composition, and as well as its kind of most important organs, the General Assembly and the United Nations Security Council. So before we get to speaking more specifically about the United Nations, it's important to firstly define, well, what is an international organization? This is mostly important, as we'll see a little bit later, because international organizations and certain like sanctioned international organizations can ask like the ICJ for an advisory opinion, for example. And so they do have a distinctive legal personality and are able to do some of the things that, states can do in the international environment. So starting out, asking, what are international organizations? It's important to note that, especially since World War II, there's been a really huge explosion of international organizations on the international scene, and they've generally recognized to have some kind of legal personality. The international organizations that you might think about are obviously the United Nations, but also institutions like the World Bank, the International Monetary Fund, who are big topics of my own research, into the International Atomic Energy Agency and the World Trade Organization. They all have a really strong influence on the course of international national affairs and even outweighs that of many sovereign states as well. So they have a really large influence. We've obviously looked at how do we define a state, which is not always a simple question, has a lot of difficulties and various things we have to consider. International organizations are also not much different in that regard. There's a lot of challenges in determining, where we would source a definition of what an international organization is. Thankfully, the International Law Commission has conducted a project on international organization responsibility, and it looked at customary international law for a definition of an organization. And it concluded that for the purposes of its particular draft articles it was doing on the responsibility of international organizations, an international organization means an organization which is established by a treaty or other instrument governed by international law and possessing its own international legal personality. So this may include as members, in addition to states, other entities as well. And then also, academics have also defined international organizations along the lines of, those entities that are created by state. They're based on a treaty, and they consist of some kind of like one organ with some kind of like distinct will that does something. But there's lots of different definitions that exist for international organizations, just like for states as well. And importantly, international organizations also have legal personality. And legal personality is essentially the status of being capable of holding rights and obligations in a legal system, just like, the states do, for example. Um, and so, it's also important to consider, well, what is the state of legal personality that international organizations have? Obviously, in domestic legal system, it's usually individual humans as well as corporations who are defined as legal persons. They have a legal personality with capacity for rights and obligations as well. But in international law, these same considerations apply relatively so. As we've mentioned, states are clearly international legal persons. They're often considered what's called like organic persons, in that their personality arises from this like historical process, which we've discussed at length, especially early on in the course. And so in this way, states in the international law realm kind of like resemble humans in the domestic legal system. But international organizations, they're more alike or more comparable to corporations in that they're created and they derive their personality from some kind of constitutive act. And also they're contained with and put together by states, just like corporations are contained with and put together by people. And in the early years of international law, it was unclear whether the United Nations and other international organizations had personality or not. And there was an issue as to whether international law as a legal system entertained the notion of persons with some kind of, persons with legal personality who are not states. And the really, really vital case on this point is that called reparations for injuries suffered in the service of the United Nations, or otherwise known as the reparations case. And it's one of the most significant cases in international law, and especially in terms of legal personality for international organizations. And just very briefly on the facts of this case, the United Nations had authorized a representative to travel to Israel in the mid to late 1940s, Count Bernadotte, and and Israel was not a member of the United Nations at this time, and Count Bernadotte was there to oversee peace discussions. And during that visit, this representative was killed by individuals from the Zionist paramilitary group, Lehi, who were infamously involved in the ethnic cleansing of Palestinian villages in the mid to late 1940s. The United Nations demanded compensation for these injuries suffered by this person and demanded reparations when the state of Israel failed to protect him. But there were lots of obstacles for the United Nations to have a legal basis to claim reparations. Firstly, it was really unclear whether the United Nations had any international legal personality so it could make a claim in its own name as an international organization, or even whether such a claim could be made by the state of nationality of the deceased. And quite surprisingly, as we've also known by looking at the UN Charter, the founding document of the United Nations is relatively silent on whether the United Nations has international legal personality. And so this question was submitted to the International Court of Justice for an advisory opinion. And just in brief, the court concluded that the UN did have and continues to have international legal personality. And the approach the court took was that to begin with, as a derived legal person, international legal personality must be granted to the organization by states. And to determine whether this grant has been made, the court first examined whether personality was granted expressly in the United Nations Charter. And as we just mentioned, it wasn't. There wasn't anything which expressly said, yes, the United Nations has some legal, personality on the international stage. And then the ICJ examined, well, was international legal personality then granted by a more implicit implication? And so the approach for this question was then to determine whether international legal personality was necessary for the purposes, rights, and obligations of the entity of the United Nations, as provided in its constitutive instrument. So, did it need to have legal personality to actually do the things that it said it was going to do in its charter? And in addition, the court also looked at the practice of the organization and how it was treated by the international community as well in trying to figure out is the legal personality necessary for the United Nations. Um, the court at this time didn't explicitly adopt a view that any organization created by international action inherently had international legal personality per se. Um, but they were looking at some express or implied grant, and was then informed by subsequent practice. And this has continued to be used in many determinations by like regional organizations. And so this approach that the ICJ laid out in the reparations case is really important to examine the powers or the questions of the powers and the international legal personality of an international organization. So international organizations in general are based on the goal usually of more efficient international cooperation, and they for this kind of purpose exercise a variety of different powers. And so this ranges from mundane powers, whether it's like negotiating agreements with a state where they're going to be headquartered, for example, which all kind of international organizations might do, to then more specialized powers like authorizing the use of force, maybe granting international financial loans, which are more peculiar and unique to particular organizations. Um, how international organizations approach the question of their powers has initially been framed as like a treaty interpretation problem, because the organization was created by a treaty. It therefore draws its personality and powers from that instrument. Um, uh, Early in the 1920s, the Permanent Court of International Justice was asked whether the International Labour Organization had certain competencies, and it looked for the grant of those competencies in its constitutive instrument. And so this was really typical of an early period of international law where states were regarded as the primary and arguably the only relevant actors. This still relatively continues this view in terms of the role of international organizations today. For example, in the Vienna Convention, Article 6 provides that every state possesses capacity to conclude treaties. Um, and the Vienna Convention for International Organizations provides in its Article 6 that the capacity of an international organization to conclude treaties is governed by the rules of that organization. So this kind of difference between the Vienna Convention, which is used for states, and that for international organizations suggests that international organizations participate in international law insofar as states wish them to do so. They don't have an inherent right to participate. And so in the case where the Permanent Court of International Justice looked at the International Labour Organization, they found that the International Labour Organization's range of competences was expressed in its founding treaty, and there was no room to understand powers beyond the clear terms of that treaty. And this kind of thinking was predominant when the United Nations was found and has continued in some form today. But there are other views now which have emerged, especially since World War II, to interpret the powers of an organization. And so what we might say is perhaps a preferred approach, taking different approaches into account, is to firstly look at and begin with the text of the constitutive instrument that it has been established by, And this would then apply the normal interpretive techniques found in the Vienna Convention, which considers not only the text of the agreement, but the context, the object and purpose of the agreement, as we've discussed in class. It might also be relevant to look at the preparatory work, the drafting, perhaps, maybe the agreements of the parties to establish the entity, and then other rules of international law, which might help determine the meaning of different provisions of the treaty. Outside of these express powers in its constitutive document, international organizations also have implied powers. And this is again where the reparations case is relevant here. For the UN to make a claim under international law against a non-state member, as in the reparations case, not only must it have had international legal personality, but it also needs to have the capacity to actually make claims against states under international law. And so this is a question about powers. And in the reparations case, the court relied on this implied powers theory. Sorry, everyone. I just had an unprovoked use of force against me by my cat. Um, Apologies about that. Now, oh my God, am I even up to the right slide? Sorry, excuse me. Sorry. Okay. So back to the reparations case. The court relied on the implied powers theory here. And under this theory, when the power is not expressly provided in that constitutive instrument, it might nonetheless be employed because it's necessary to achieve the objectives of the organization. And so we consider, for example, if whether the United Nations has the power to enter contract to lease an automobile, subscribe to an internet provider, for example, neither of which are actually provided for explicitly in the UN Charter, but surely, the organization must be able to do those things to fulfill its tasks listed in the Charter. And there is another way of thinking about powers that international organizations have. But this is quite a controversial way of thinking about powers for international organizations. And it's generally framed around, are there powers that an organization inherently holds? And so these would not be powers the organization received by expressed grant or implication, our two other methods, but the kind of powers that it holds as a result of its kind of nature and being. And this theory overturns the assumption that we're kind of discussing that organizations can only enjoy powers they are given. So the tricky part of this approach, though, is actually enumerating which powers could be inherent. Some powers seem to be good candidates for this, such as like treaty making power. That would kind of make sense. International organization inherently should be able to make treaties, for example. But more powers, which are more unique to each organization, would be more difficult to define. And this was an issue during the International Criminal Tribunal for the former Yugoslavia. Excuse me. Sorry, team, and we're back. That was just another unprovoked act of aggression. But I've now hopefully separated him enough and removed enough things that he can't cause any havoc. My apologies. Just got to, can't separate myself really too much from them, unfortunately. But as I was saying, when we're thinking about like the inherent powers of international organizations, this was an issue in the International Criminal Tribunal for the former Yugoslavia, prosecutor versus Tadic. And in this case, the criminal tribunal asked whether the respondent Tadic was in contempt of court and whether the tribunal had jurisdiction to address this issue of the contempt of court. And the tribunal noted that there wasn't any mention in the tribunal's statute of its powers to actually deal with contempt. But the tribunal had an inherent jurisdiction which derived from its judicial function to ensure that its exercise of its jurisdiction, which is given to it by that statute, is not frustrated, and that its basic, inherent judicial functions must be safeguarded. And so as an international criminal court, the tribunal must therefore possess an inherent power to deal with conduct which interferes with its administration of justice. And this content of that particular inherent power by the International Criminal Tribunal um, can be discerned by reference to the usual sources of international law, which the tribunal analyzed, and it found that it had the power to punish conduct which tends to obstruct or abuse the administration of justice, because it's necessary to ensure that it can exercise jurisdiction which is expressly given to it by its statute, so it's not frustrated, and so its basic judicial functions are safeguarded. So the power to deal with contempt was clearly inherent in its inherent jurisdiction. Now, there's other aspects of the autonomy of international organizations which are important, and this is especially around immunities. And this is kind of relatively similar to the immunities that we discussed around states as well, which ensures some kind of a degree of physical autonomy, so that these international organizations can act independently of any particular state interest, free from political pressure. Organizations and staff, that they need to enjoy these immunities so they can actually ensure the organization functions. And the usual explanation for international organizations having privileges and immunities is to ensure that the organization can operate independently without the undue influence of any government, especially the government of the host state where the international organization is located. We don't go into a huge amount of detail or any detail as to what these immunities and privileges are, but it's just worth noting that these international organizations do have some of these. And we did actually, some of our tutorial groups did kind of look at this when we were considering the International Finance Corporation a few weeks ago in our tutorial, and whether they were immune from a legal suit in the United States. And let me progress the slides. There you go. So now we're at the United Nations. So we will look at the United Nations in not huge amounts of detail, but hopefully just the stuff that is, necessary to know. And of course, you probably will have a bit of knowledge about the United Nations just from hearing about it quite frequently, and maybe you've also spoken about in other courses as well. But as you also know, the United Nations is kind of like the second attempt to establish some kind of global international body since the destruction of World War One, and its creation began as the end of the Second World War came into view. Where there was a lot of effort being poured into different forums and conferences to promote this vision. And the relationship between the ending of the League of Nations and the beginning of the new United Nations is actually more complex and untidy than it's usually presented, because the United Nations Charter actually entered into force at the end of October 1945, and the League of Nations was not actually dissolved until mid-April in 1946. So although the League of Nations actually continued in 1946, it was really considered to all and sundry that it was effectively dead and had been for quite a while. And there was meetings as World War II was raging, and even beforehand, to discuss the future of this, permanent global body. Because, like as we've mentioned before, the League of Nations had many failures even before the explosion of World War II and the horrors that attended that awful conflict. Now, for the United Nations, once it got started, it had a really remarkable expansion in terms of its membership, its structures, activities, and one of the first major expansions and remarkable achievements was the terms of the United Nations Charter, and they have been used constantly in international law since that time. They're usually interpreted almost on a daily basis, whether by member states of the UN, organs in which they participate, by different legal councils of the United Nations. So the UN Charter is really central to international law and international relations more broadly, which is quite a phenomenal achievement. And also, there were amendments to the Charter also envisioned as well. Article 108 talks about how amendments shall come into force for all members of the UN when it's adopted by a two-thirds vote from the members of General Assembly and then ratified by two-thirds of the members of the UN, including all the permanent members of the Security Council. These are very, very rare. But it still provides some kind of mechanism for reform of the United Nations, which is also a major development in this particular organization after World War II, as compared to the League of Nations. So for today, the United Nations consists not just of six principal organs which are stipulated and enunciated in its charter, but of many, many bodies that deal with all kinds of things, whether it's like economic cooperation and trades, like the United Nations Conference on Trade and Development, the United Nations Industrial Development Organization, and also human rights. It has, high commissioners for human rights, different centers of human rights. It has disaster relief. It has the UN Human Rights Council as well. There's lots of dispute settlement mechanisms outside of just like the ICJ. There's also particular bodies established with judicial functions, such as the International Tribunal for the former Yugoslavia as well, and that of Rwanda, and various hybrid tribunals as well. So there's a huge number of sub-organizations and bodies associated with the United Nations. And so these various bodies and even international courts associated with the United Nations couldn't really have been envisioned in 1945. And that's even though Article 29 of the Charter gives the Security Council power to establish subsidiary organs as it deems necessary for the performance of its functions. But there's nothing. One of the other really significant developments of the United Nations has been United Nations peacekeeping. And there's nothing really in the text of the Charter to hint at UN peacekeeping, which has been a hugely major important part of the United Nations since 1957, and especially since the 1990s. But the establishment of peacekeeping lay in those arguments around, the inherent or implicit powers of the United Nations, which we spoke about. Now, as of middle of June 2023, the United Nations has 193 member states. So it almost has near universal status. And so the principles that are within the Charter are considered generally to be almost, if not actually, customary law. The Charter is a multilateral treaty binding upon its member states that creates a permanent venue for diplomatic relations, and it established the basic procedures and structures of the organization. The most forceful tool at the disposal of the United Nations is the binding nature of Chapter 7 resolutions by the United Nations Security Council when it finds that there is a threat to international peace, which we talk about later. As of today, the United Nations' main areas of work are international peace and security, the protection of human rights, humanitarian aid, sustainable development, and climate action, and upholding international law. So the United Nations and its associated international organizations were created to perform certain functions. And that then has ensured there's certain consequences for the position of states vis-a-vis their relationships with them and their mutual relations with these international organizations. So the greater the powers vested in these organizations, the more the freedom of member states was seen to be limited. And since the United Nations authority to perform its functions is derived from the consent and to this kind of arrangement by member states in accepting the United Nations Charter, the organization can only act within the framework of the powers set out in the Charter. So it must act within those powers. So it has express powers stipulated in the Charter. It has also implied powers, which we noted where that idea of implied powers comes from, which aren't expressly stipulated, but arise out of a necessary implication of what has been expressly conferred. And this is like, the example of the need to contact an internet provider in the host country, for example. So you need the internet to be able to do peacekeeping, for instance. And so there's a really non-exhaustive, huge number of examples of these implied powers that the United Nations has, so it can do its express powers. And the purposes and principles of the UN are set out in Articles 1 and 2 of the Charter. And this is the underlying rationale for all the powers of the United Nations. So it operates as a limitation for the organization. So it only has those powers that are directed at furthering these articles. And this also extends to helping us find the implied powers and interpreting the meaning and the scope of the express powers. Now let's look at the organs of the General Assembly of the United Nations, including the General Assembly. And the General Assembly is the organ with a nearly universal membership, with an extremely broad mandate. It's also said to be the world's leading forum for political discussion. And for most of the history of the General Assembly, it was defined by the poles of the Cold War. And because of the Cold War and the almost like frozen ability of the Security Council to actually function, the General Assembly became really influential, even more so than it was probably intended to be by the drafters of the United Nations Charter. Early on, when the General Assembly's membership included a large number of Western and American states, which the United States had an overwhelming influence on the voting patterns of the Latin American states, many characterize the General Assembly as a Western organization for all practical purposes. However, with decolonization in the 50s, 60s, and 70s, then led to a significant increase in the number of member states, especially from Africa and Asia, with then it growing significantly to now have 193 member states, which is nearly 4 times its original membership of 51. So we can divide the General Assembly's functions into 2 primary categories. The first one kind of relates to its role as an overseer of the organization and the other principal organs, such as issues relating to membership, financial matters, and oversight. And then also those functions that relate to the attainment of the purposes and principles of the UN Charter. And this is like the maintenance of international peace and security, development of friendly relations, and achieving international cooperation. But it's important to note that the UN General Assembly resolutions, with the exception of budgetary matters in Article 17, are not formally legally binding. But they can be considered expressions of state practice and also opinio juris to support the formation of customary law. So like the resolutions can then, from the UN General Assembly, can gain status as customary law, such as the Universal Declaration of Human Rights, for instance. And another important function of the UN General Assembly is a permanent multilateral diplomatic forum. So it can request advisory opinions from the ICJ to then contribute to the development and articulation of the current status of international law. Now, the Security Council is unique among the principal organs of the UN in 2 major ways. The member states agree to accept and carry out the decisions it takes in accordance with UN charters, and also member states have conferred upon it the primary responsibility of the maintenance of world peace and security. And the Security Council has been more productive and has expanded its activity considerably since the end of the Cold War, when during most of the Cold War it was locked into a stasis because of the major world powers not often cooperating in that forum, the Soviet Union and the United States, as well as China as well. But there's still obviously a lot of issues today. Still, permanent members of the Security Council wield their vetoes frequently, and often arguably to put their national interests ahead of their responsibility to protect international peace and security, which then has frequently led to the Security Council being unable to pass important resolutions. And when it is able to pass resolutions, their content is frequently watered down, which then leaves the actual intention or the actions required really unclear, which then also reduces the credibility of the Security Council more broadly. But it still remains a highly politicized organ with very limited transparency in its decision making. And still, its voting system is that of what has been previously, where 5 permanent members disproportionately influence the operation of the Security Council and then the United Nations as a whole, which has become a growing source of dissatisfaction over the years and especially more recently. But the Security Council does have certain functions that relate to the successful working of the United Nations, including those that impact the functions of other principal organs as well. But it does have arguably a smaller role than that of the General Assembly in terms of other principal organs. And so it does, however, have functions which pertain to membership in the UN, such as admission, suspension, for example. It has functions in the appointment of the Security General, the election of ICJ judges, and conditions whereby a state may become a party to the statute of the ICJ, calling emergency and special sessions of the General Assembly, and also amending the Charter and the statute of the ICJ. It also has powers there too. So the work of the Security Council, we might say, primarily relates to the maintenance of international peace and security. And the members of the UN, being the states, have given it primary responsibility within the organization to do that. And this is carried out in terms of ensuring peace and security through the powers bestowed upon it under Chapter 6 of the UN Charter, which deals with pacific settlement of disputes, and then Chapter 7, which deals with action with respect to threats of peace, breaches of the peace, and acts of aggression, which we'll also deal with when we look at the use of force. Chapter 8 then deals with regional arrangements, and Chapter 12 deals with the international trusteeship system, which the Security Council both also has actions in. But we can also divide its peace and security functions into a few different categories. So it has a role in disarmament, the peaceful settlement of disputes, enforcement, which includes different peace and security arrangements, and also functions relating to very strategic areas in trusteeship agreements, which we don't really go into too much. Now, the last major body we'll have a look at in terms of our United Nations portion of this lecture is the Secretariat. So Article 7, subsection 1 of the UN Charter provides that the Secretariat, or the General Secretary, is one of the 6 principal organs of the UN. The organization of the whole Secretariat was provided for by in the General Assembly Resolution 13I in 1946, one of the very early ones. It had at that point diverged quite a bit from what international organizations had previously done, where previously early international organizations had been staffed by nationals of the home country or officials on secondment from their governments, which is also heavily criticized because this was generally staffed with bureaucrats and administrators from colonial countries. But the Secretariat of the League of Nations and later the UN was based on this notion of an international civil service. So the Secretariat is composed of the Secretary General themselves and their staff, which is in accordance with Article 97 of the UN Charter. The Secretary General is the head of the Secretariat and responsible for appointing the staff. They are the chief administrative officer of the United Nations. But the UN Charter is actually relatively silent as to the functions of the Secretariat. But the Secretariat in practice carries out the diverse day-to-day work of the UN. And this derives from its role in supporting the organs of the United Nations and the specific tasks given to it by the Secretary General. So this is like the mostly what we're going to talk about in terms of the United Nations. The work of the United Nations will come up again when we are talking about the use of force, and also in the next couple of weeks as well. And we've also been given some hints or nods towards the United Nations in previous weeks as well. But this is kind of a broad overview, and really, I mean, the most important points I think so far is around understanding the international legal personality of any international organization. This is really quite crucial, and especially the reparations case as well, um, and also having a look at which international organizations can like request advisory opinions from the ICJ as well. These are really important topics, which are even bigger than the United Nations in and of itself. So now we're going to move on to the use of force. This is also a complex area, and also highly controversial as well, because the use of force is one of the like most solemn and typically difficult decisions that a state can actually take. And there is a lot of regulation about the use of force, and it's one of the most fundamental areas of international law. And as we've already noted, the prohibition of force contained within Article 2, subsection 4 of the UN Charter is referred to as the cornerstone of the international community. And there's really, and is really the centerpiece that ensures the self-preservation, the protection of sovereignty of the member states as well. And this is what international law is mostly concerned with. So really crucial part of international law. But because of this, because of the competing pressures and controversies of sovereignty and the state's ability to act, this is one of the most controversial areas within the broader field of international law. And also one of the other reasons why it's so controversial is because it is relatively simple in terms of how it is provided for in the UN Charter. It actually has not that many articles, with many of the points of the articles opened up to very broad interpretation. That's if we compare it with something like the law regulating armed conflicts or international humanitarian law, which we look at next week, which has numerous dedicated treaties and conventions. Whereas the use of force is kind of like regulation at its almost most minimal. So in terms of the history of this concept of the use of force, the idea of states resorting to war and resorting to brute strength and power to resolve disputes has really, if we're going to try to tie it back previously, it has been really one of the most historically consistent aspects of state practice throughout history. Whether states themselves or empires or different forms of political organization, the resolve to use force has been something that's been a relatively constant feature. From the earliest peoples, religious entities as well, to the rise and fall of empires, to now the modern state, and even today, especially with non-state actors too, there has been continued questions around the use of force, and it's continued to be a live and controversial area. And even though we have provisions around the use of force in the UN Charter, which we'll talk about, there has actually been attempts to regulate the use of force, even traced back to the most ancient of times. And the earliest form of regulation of the use of force can be found in the idea of the just war, or bellum justum, doctrines from classical Greek and Roman philosophers such as Cicero, which were then subsequently drawn upon and developed by various Christian theologians of the Middle Ages, such as St. Augustine and St. Thomas Aquinas. Moralistic instinct led to conditions being placed upon the launching of war to try to restrict its prevalence, and the human physical destruction and costs that were associated with it. And so there was a attempt to ensure that war could only be launched under the authority of a sovereign. It required a just cause, such as a reaction to some kind of prior wrong, and it must have been launched with the rightful intention, such as doing justice or attaining peace. And this just war doctrine then became tied in with the Church and the Holy Roman Empire, with the court providing a means of the papal court providing a means of discriminating between just and unjust belligerents and handing down appropriate sanctions to the unjust belligerents. Um, there were many different conceptions of the just war doctrine, but if we're going to turn back to our favorite uh, international classical legal scholar, Hugo Grotius, Hugo had a very classic a statement on the concept of just law, which was said to have created a concept which synthesizes the theological canonist tradition of just war with the civilian tradition of legal war, is how Grotius described it. Then, after the Treaty of Westphalia, and then during the following centuries, the dominant doctrine appears to be that the jus ad bellum withered to the mere recognition that sovereign states had a right to resort to force or war to pursue their claims or protect their security and interests. And international law was viewed as having become more indifferent to the use of force by states, so that the decision to go to war was not a matter of law, but one of expediency. And so war became basically an essential instrument of statecraft or a pursuit of policy by other means, as it was famously described. So while there was really few legal constraints upon the state's right to resort to force at the height of these ideas of state sovereignty in the 18th and 19th centuries, states were still expected to have some kind of justification for their actions, even if it was for political purposes. A really well-known illustration of this is the correspondence between Great Britain and the United States of America following an incident in 1837, which involved the sinking of a US ship, the Caroline, by British forces on the US-Canada border, in which the importance of being able to justify the actions of the British as self-defense was agreed upon between the parties. And so, although these states at this time had a right to resort to force, the just ad bellum concept hadn't been emptied of all its meaning. Like states didn't have to, had to justify their actions in reference to this idea of a just war. And we will return to that Caroline case soon in some more detail because it's a very important one. Now, although it's very debatable whether any legal restraints would have prevented the calamity of the First World War, this crucial event initiated some kind of moves towards legal regulation of the use of force, or some kind of serious attempt at collective security. And as we've mentioned before, the League of Nations did represent this first permanent international effort with the aims of maintaining world peace, as well as the first attempt at some kind of legal regime of collective security. And the Covenant of the League of Nations contained an obligation not to resort to war, and a declaration that any war or threat of war was now a concern to the whole League of Nations, and the League shall take any action that may be deemed wise and effectual to safeguard the peace of nations. So this was a really important landmark, but there were lots of qualifications and loopholes within the League of Nations itself, and also the Covenant too, as a document. So even though members of the League of Nations were obliged to submit their dispute, which was likely to lead to a rupture in relations to arbitration, judicial settlement, or the League Council, they agreed not to resort to war only for 3 months after the decision by the court, the award of the arbiters, or the report by the League Council. So they could then just go to war anyway. And if the court failed, or the council, failed to reach a report on a dispute which the parties unanimously agreed to, then the members of the League reserved the right to take any action that they'd like. So obviously, the League of Nations was not a strong legal regulation against the use of force, and obviously had lots of different problems, which was arguably involved in leading to the calamities of the Second World War. Then finally, at the end of that dreadful conflict and the atrocities and the crimes committed within it, nations finally came together to try to address this. And as we noted, they adopted the United Nations Charter and established United Nations with which had the primary purpose of maintaining international peace and security. Um, and it also allowed the notion of a legal regulation of the use of force to enter into the international arena more formally. Um, so this was trying to move past the previous efforts, which these attempts to regulate war was basically totally redundant or effectively redundant, to an era where there was some hope there'd be further success. And we could argue certainly there was some success in some parts of the world for a majority of history since 1945. And as we mentioned previously, the prohibition on the use of force is importantly located within Article 2, subsection 4 of the UN Charter. And the major significance of the provision is that it comprehensively prohibits force as opposed to the broader concept of war. So it doesn't just prohibit the launching of aggressive wars, but also covers those acts involving the use of force that fall short of an actual like formal declared war. So importantly, looking at the Charter in some more detail, this prohibition on the threat or use of force is described, as I mentioned, as a cornerstone of the international community. And it explicitly says all members shall refrain in the international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. This prohibition is not just in the UN Charter, and while it's kind of been worded differently in some respects, we can also find it recited in other instruments like the UN Convention on Law of the Sea, the Rome Statute on the International Criminal Court, the United Nations Declaration of Principles of International Law concerning friendly relations and cooperation among states, the Rio de Janeiro Inter-American Treaty of Reciprocal Assistance, the Helsinki Final Act, and many others. So it is something that is more broadly enunciated in various instruments. But it's also importantly found in customary law, which is, as we've mentioned, a really important aspect of the international legal regime as well. And the International Court of Justice noted in the Nicaragua case, which we've briefly mentioned before, that there can be no doubt that the issues of the use of force are issues which are regulated both by customary international law and by treaties, in particular by the United Nations Charter. So importantly, there is that strength of the prohibition in customary law as well. And there has been particular emphasis placed upon a textual analysis of this section to argue for limited constraints. And many authors have asserted that the use of the phrase against the territorial integrity or political independence of any state in Article 2, subsection 4 suggests that force is permitted so long as it does not target those two fundamental elements of statehood, that being territorial integrity and political independence. But this kind of very narrow interpretation has really been rejected by most scholars. And mainly this is because it creates what's called an Orwellian construction of the terms of this provision. And others have argued for a tight reading of the prohibition. But the documentary evidence of the negotiation, discussions, and drafting of the treaty itself, which is also known as the Travaux Préparatoires. I don't think I've said that right, but I've written it on the slides there. This has also indicated that the inclusion of this wording was not seen as limiting the prohibition of the use of force, but to provide a particular emphasis to protect these attributes of statehood. So even though some scholars and theorists do try to read this very narrowly to just be prohibiting use of force against territorial integrity and political independence. Having a look at this Travaux Prep le Trois, uh, it actually demonstrates that the drafters had in their mind that they weren't trying to actually limit this, but they wanted to put particular emphasis on this point. Um, and then also an additional argument, which is often advanced to evade this application of Article 2, subsection 4, is a claim that a state is reclaiming territory which is rightfully theirs. And this was the basis for India's invasion of Goa in 1992, as well as Argentina's invasion or attempted seizure of the Falkland Islands from the United Kingdom in 1982, and also Iraq's invasion, occupation of Kuwait in 1990, which all received widespread condemnation. And the condemnation was because the fact that the border disputes between states are so frequent that any exception to the prohibition or threat or use of force for territory that is allegedly occupied unlawfully would create a really large and dangerous hole in the fundamental rule of international law if states could just simply try to take what they felt was theirs. So it's important just to note some of the history and scholarly work which has tried to limit the applicability of Article 2, subsection 4 in terms of the use of force, but most of this has been relatively rejected. So the prohibition does appear almost to be absolute on the face of it, but the breadth and scope of the prohibition is more limited by the article's reference to its application in the international relations of member states. So it applies to the use of force by all members, which has a restricted membership of the UN to states, and only in their forcible actions against any state, which is obviously not a totally surprising restriction because the Charter was made at the time where the state was the principal, primary, and often only subject within international law. And so there is therefore then exceptions of what we might describe as contested states, as well as non-state actors and armed groups that do not fall within the scope of this provision, and through a particular reading would then seem to be not prohibited from threatening or using force under it. But it's clear from the original intention behind the prohibition was for it to apply to interstate situations and not those of intrastate or domestic nature. But it doesn't, in this kind of respect, expressly prohibit states from using force internally in domestic situations, which is more governed by domestic law, human rights considerations, and the law governing non-international armed conflict. So Article 2, subsection 4 omits qualifications as to what the force is. So, what does force mean? That is the intended target of the prohibition. And the UN Charter is silent on this point. Other instruments adopted within the UN doesn't also offer any kind of direct assistance in this regard. And generally, we might think of force being any kind of power, violence, or pressure directed against a person or thing. And even though force isn't defined in the UN Charter, this concept is not expressly defined, the preamble to the UN Charter clearly states that the overriding purpose of the UN is to save succeeding generations from the scourge of war. Which isn't, again, not very surprising given that the Charter was drafted in the wake of 2 world wars and other atrocities such as the Holocaust. But it also restricts itself to stipulating that it is armed force that shall not be used, save in the common interest. And a qualification of the term force is also employed at other points within the Charter. And so it could be argued that because references to force elsewhere in the Charter are to the armed force variety, then this also holds true for Article 2, subsection 4. And this goes back to one of your founding kind of principles of statutory interpretation, that if you're not how what a term means at one specific point, you can have a look throughout the legal instrument as how it's used elsewhere to help you understand how it could be used. So then the prohibition of the use of force within Article 2, subsection 4, is restricted to the force of an armed nature. Um, and so having said that, even with that interpretation, other documents, such as the Declaration of Friendly Relations, Definition of Aggression, the Declaration of the Non-Use of Force, which are considered to be reflective of customary law on the basis they were also adopted by consensus, would appear to support a more restrictive view of the provision of the application of Section 2, subsection 4 of the UN Charter to armed force. But there's really no definitive conclusion exactly what that might what force really entails. There is, though, the prevailing view among the broader academic community and with judicial interpretation that it is armed force as opposed to that of a political or economic nature that's covered by Article 2, subsection 4. We won't go into a huge amount of detail of how we define, armed force and how it is defined, but it might be worth to conclude this point to think that for the purposes of the prohibition on the threat or the use of force, the key concept of force can be defined as the intentional coercion of one state of another through the direct or indirect use of an instrument which is at least capable of causing human harm or physical destruction. Now, importantly, it does also cover the threat of force. Um, and as with the actual use of force, the UN Charter doesn't provide any elaboration upon what constitutes a threat, and states themselves, haven't expressly elaborated upon the legal nature of threats of force and the circumstances in which the prohibition would be infringed. And instead, the International Court of Justice has been a focus for discussions here. And it declared in its 1996 Nuclear Weapons Advisory opinion that, and I'm quoting here quite extensively, if the envisioned use of force is itself unlawful, the stated readiness to use it would be a threat prohibited under Article 2, paragraph 4. The notions of threat and use of force under Article 2, paragraph 4 of the Charter stand together in the sense that if the use of force itself in a given case is illegal for whatever reasons, the threat to use such force will likewise be illegal. In short, if it is to be lawful, the declared readiness of a state to use force must be a use of force that is conformity with the Charter. So in other words, the ICJ treats threats of force as prohibited if it would be unlawful to employ actual force in those same circumstances. And this particular manifestation of force has been defined elsewhere as like a message, which is explicit or implicit, formulated by a decision maker and directed to a target audience, indicating that force will be used if a rule or demand is not complied with, as well as an express or implied promise by a government or a resort to force conditional on non-acceptance of certain demands of that government. So on this basis, the ultimatum, which is given by the United States and the United Kingdom in 2003, prior to the invasion of Iraq, for Saddam Hussein to leave the country or be forcibly removed was unlawful. Although the US-led coalition justified its action upon a revival of the authorization to use all necessary means that had been issued by the UN Security Council for the forcible eviction of Iraq from Kuwait in 1990 to 91, several years before, this argument was not accepted by other members of the United Nations Security Council and also large swathes of the broader international community, and so rendered the threat to use such force on that basis and at that time totally unlawful. But on the basis of the International Court of Justice depiction of threats of force in the Nuclear Weapons Advisory opinion, while the threat would need to be coercive in nature, there would not seem to be the need for it to be accompanied by a particular demand or ultimatum, despite the fact that this would normally be the case given the very nature of threats. However, all that the ICJ seemed to require was a stated or declared readiness to use force. Now, looking at self-defense. The source of the right of self-defense is contained within Article 51 of the UN Charter. And quoting it here, it says, nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by members in the exercise of this right of self-defense shall be immediately reported to the Security Council and shall not in any way affect the authority and responsibility of the Security Council under the present Charter to take at any time such action as it deems necessary in order to maintain or restore international peace or security. So this right was not one that was to be originally included within the Charter and was not a right included in any of the previous attempts at regulating the use of force within the Covenant of the League of Nations, for example. But it was included within the United Nations Charter at the insistence of some South American states that had previously entered into a collective self-defense arrangement regionally in order to protect the right of collective self-defense. And in addition to the right, also existing in general within customary law, as the ICJ stated in the Nicaragua case, there are two specific requirements contained within the customary source of this right. That is, any military action taken as self-defense has to be necessary and has to be proportionate. And this stretches back to also the Caroline incident that I briefly mentioned before that occurred in the United States and Canada on the border in the 19th century, which we talk about soon. Now, of all the elements of Article 51, the one that generates the most discussion is the requirement of an armed attack. So the requirement remains that the only prerequisite for the invocation of the right for self-defense is this requirement of an armed attack, and the ICJ has confirmed that nothing short of an armed attack will be sufficient to trigger the right. And Article 51 hinges on this expression of armed attack. It's a threshold requirement. Recourse to self-defense under 51 is not vindicated by any violation of international law, which falls short of an armed attack. But this apparently quite simple phrase, if an armed attack occurs, also masks a lot of disagreements as to the sort of actions that might constitute such an attack. The possible perpetrators of such an attack, how and when states may respond, when one begins and ends, and whether a threat of an imminent or even more temporarily remote armed attack is sufficient to justify the invocation of the right to self-defense. So these problems and the issues with finding answers to these questions are also exacerbated by the Charter because it's generally silent as to what constitutes an armed attack and when it can be said to commence and terminate. And the first issue here, which is also not uncontroversial in itself, is whether the definition of armed attack in Article 51 of the Charter and the related customary international law requires the perpetrator to be a state. And while we spoke about that Article 2, subsection 4 expressly arises in the context of international relations, Article 51 contains no such stipulation. And so this is a pertinent question that needs to be addressed, which is whether the actions of non-state actors are able to constitute an armed attack for the purposes of the right to self-defense. And there is nothing in Article 51 that restricts the invocation of the right to attacks by state actors. And in addition, while taking place in the 19th century and before the force was legally regulated, the Caroline incident, which has been described as like the authoritative source for self-defense, was itself an example of an action in self-defense against the activities of non-state actors. But there is still quite a division of academic opinion on this particular issue. Some scholars maintain that maybe a traditional view that the right of self-defense only exists in connection with an attack by a state actor, which would appear at first glance to be a consistent line taken by the ICJ, which has been also strongly critiqued. So, for example, the court stated in the Wall advisory opinion that we've mentioned before that Article 51 of the Charter recognises the existence of an inherent right of self-defense in the case of armed attack by one state against another state. And in that case, when Israel was constructing the separation wall, it was not claiming that it was protecting itself from an attack that is imputable to a foreign state. And so for this case, where the ICJ was given an apparent need for the author of an armed attack to be in the form of a state, there was a huge amount of critique on that point because this is obviously an issue where you have non-state actors, including terrorist groups, who would also constitute armed attacks. And this was also an issue that was before the Nicaragua case, which appeared to at least claim that there had to be some kind of attribution of a non-state armed group to a state party. But more contemporaneously, it's probably fair to say that many states and even scholars of international law are of the view that non-state actors are qualified in their own right to perpetrate an armed attack under international law. And this has especially been invoked since the attacks of 11th September 2001 or 9/11, where self-defense was specifically invoked by the United States in the face of attacks by the non-state terrorist group Al-Qaeda, but also the justification of self-defense appeared to not be simply passively tolerated by the international community, but rather widely accepted, with very few dissenting states. And there was a few Security Council resolutions, 1368 and 1373, which also mentioned this. And even though at the time of their adoption, it wasn't entirely clear who the perpetrators of the 9/11 attacks were, the resolution still reaffirmed the right of self-defense in light of the attacks. And so even though the perpetrator of an armed attack need not be a state, it's generally accepted that the entity that is invoking the right of self-defense, will be. And so Article 51 talks of the occurrence of an armed attack against a member of the United Nations, so therefore being a state. Now, in terms of, what's then required of self-defense, the two major important principles are necessity and proportionality. And the principle of necessity was a prominent one in the Caroline affair, and today plays also an important role in self-defense, including the effect any action taken by the Security Council has upon the continuing validity of a claim to self-defense. So going into this really important case a little bit in some more detail, the Caroline was a merchant ship which had been taking arms, men, and other supplies from the territorial waters of the United States to Navy Island on the Canadian side of the border to assist rebels positioned there in their fight against British rule in Canada. And then on the night of the 29th of December, 1837, the Caroline was set on fire whilst on the US side of the border by British forces and then sent over the Niagara Falls, which destroyed the ship and killed several individuals on board. And so the incident took place upon US territory, and so the US government was outraged about it. And during the course of the correspondence between Great Britain and the United States over this incident, the US Secretary of State, who was Daniel Webster at the time, asserted what was or what came to be known as the Webster formula. And he wrote that it will be for the British government to show a necessity of self-defense, instant, overwhelming, leaving no choice of means and no moment for deliberation. It will be for it to show also that it, even supposing the necessity of the moment authorized them to enter the territories of the United States at all, did nothing unreasonable or excessive, since the act justified by the necessity of self-defense must be limited by that necessity and kept clearly within it. So this point was accepted by Lord Ashburton, who was the special envoy of Great Britain to the US. But it's also significant that neither war nor the use of force was actually prohibited at the time of this incident. And so the question wasn't whether Britain had lawfully exercised its right to self-defense, but rather whether it could use forcible measures of self-defense within American territory without plunging the two countries into war. So it is an issue of political nature rather than a legal one. And so it's difficult to say whether this has generated customary international law on the limitations of the right of self-defense because it took part it took place in a broader absence of a prohibition of the use of force. But this Caroline incident has attained a really important authority in international law and has been pointed at as the kind of classic case of the law of self-defense, and especially the two criteria of necessity and proportionality that represent the defining features of the correspondence, and it's certainly central to the right as it exists today as well. But there's no clear-cut rules determining how states will regard the necessity of any military action taken in self-defense. And a lot will depend on the individual circumstances. But it's possible to isolate two clear elements of this criteria: that there's no reasonable alternatives to the use of military force, and that any military force is undertaken and done so in the purpose and pursuit of defense, as opposed to retaliatory or punitive objectives. Now, the connected principle of proportionality basically exists to serve as a constraint on the scale and effects of defensive action, which is again said to be in the very inherent concept of self-defense. And this is also used often as a criterion where states evaluate each other's acts of self-defense. And this notion of proportionality differs depending on whether it's being discussed that action is being taken under the jus ad bellum, or the right to war, or the jus in bellum, or justice in war, which is not always clearly discernible when distinctions or assessments of military action are taken place. So, for example, where jus ad bellum intends to measure the force used in an operation of self-defense in its kind of entirety, the idea of jus in bello, or justice in war, considers the force applied against a specific military target defined by international law at any given point in that operation. So the jus ad bellum, or the right to war, is the forceful response as a whole that must be scrutinized in terms of whether it's proportional, instead of singling out specific attacks. Whereas the jus in bello, or justice in war, focuses on those more specific points. And just as the principle of necessity, the principle of proportionality is not underpinned by concrete guidelines. And so while it's been claimed that the precise parameters of the principle of proportionality cannot be configured exactly or with precision, which is usually to be expected from the law, it's also been said that it's shrouded in uncertainty. And so there's many ways in which these principles could be viewed. So one way of looking at it is that the response in self-defense might be required to be quantitatively the same as the prior attack in terms of overall force used, damage caused, or casualty suffered. And this idea of proportionality was seemingly advanced, for example, by Russia when it stressed the force used against Georgia in self-defense in 2008 did not go beyond the scale of the attacks it was subjected to. And another alternative way of looking at it is that the principle of proportionality might require that the response in self-defense be qualitatively equivalent to the prior attack or threat, for example, in terms of the weapons used or the nature of the armed attack. And this approach would mean that in many situations, the victim state might be permitted to be either overly destructive in its response or instead be deprived of the opportunity to effectively defend itself. But it's not one that appears to have found consistent acceptance in state practice historically. And the kind of last way of conceptualizing proportionality is that it might be interpreted as providing that the defending state should do more than achieve its specific defensive objectives, so that it can only take measures that are necessary to be able to effectively halt and repel an armed attack. And this is the approach that is arguably generally more reflected in state practice, and maybe not so much exactly in our current moment, but it certainly has been historically, and also the one that is best supported by the scholarly literature. Now, preemptive self-defense is another controversial point of self-defense. And again, Article 51 provides the right of self-defense if an armed attack occurs. But there's nothing really in the Charter or other documents that guides us on the temporal meaning of this requirement. So a literal reading of this would suggest that an armed attack needs to be physically occurring or has occurred in the recent past with some kind of continuing defense necessary. Um, but this has become an issue in sharp focus in recent years, and again, more and more since especially the aftermath of the attacks of 9/11, which is whether the right to self-defense can be invoked before an armed attack has been launched, or at least before the physical manifestation of one has begun to occur. And so anticipatory self-defense is employed to describe the taking of defensive military action at the point immediately preceding the physical launching of an armed attack. But it's more difficult to reconcile this anticipatory self-defense with Article 51 saying if an armed attack occurs stipulation. Again, if we look at the Caroline incident, the classic source of self-defense, it required that there be a necessity of self-defense, instant, overwhelming, leaving no choice of means and no moment for deliberation. And it's an increasingly accepted view that if self-defense is to be resorted, then the armed attack would need to be imminent, as stated in the Caroline correspondence. Again, this point is not free from controversy and disagreement. And this idea or concept of imminence has been used, which came from the Caroline incident, has been used during the post-World War II era in determining at which point the right of self-defense might be resorted to, and when it might be said that an armed attack has begun to occur. Then there's preemptive self-defense, which is armed action, which is taken to prevent more temporarily remote threats of an armed attack rather than an anticipatory, which is more imminent. So to try to frustrate some kind of armed attack at some point in the future. So targeting the facilities of a hostile state that are believed to be developing a nuclear capability is an example of this form of self-defense. And this is a self-defense was invoked by the United States and Israel in the recent bombings of the nuclear reactors in Iran. And this argument had its proponents during the Cold War as well, especially due to the threat posed by nuclear weapons. And this argument was the argument was made that the destructive potential of nuclear weapons is so enormous as to call into question any and all received rules of international law regarding the use of force. But it's important to note as well that while an argument can be made that the concept of self-defense against a temporarily imminent threat, that is one, that's objectively highly likely to occur in the immediate future unless some kind of action is taken, is reconcilable with the requirement of an armed attack, even in a difficult manner. The notion of self-defense under a preemptive doctrine against a temporarily remote threat of an attack where there's little to knowledge as to if or when or how, and possibly against what or whom the attack may be launched is a bit more difficult, well, a lot more difficult to reconcile with Article 51. So it's been said that the arguments in favor of the preemptive self-defense are a direct and open challenge to Article 51 of the UN Charter. And it's been highly controversial, and especially so again after 9/11, where the so-called Bush Doctrine, named after George Bush, allowed for a widespread right of this preemptive self-defense of, particularly the United States, to engage with what it saw as hostile forces and hostile countries around the globe. Now, moving on to collective self-defense. I know we've been going on a little bit, but I don't think we have too much more to go, perhaps maybe 10 or so minutes. But these are also important points in what is a very large and important topic. So in addition to this defense, this right of individual self-defense, Article 51 does make reference to the right of collective self-defense. And this has been invoked on several occasions, such as by the US and Lebanon in 1958, United States and Vietnam in 1961 to 75, the Soviet Union and Czechoslovakia in 1968, and Afghanistan in 1979, and many other states after 9/11, and also by various states in Iraq in response to the attacks by the Islamic State group from 2014. but this idea of collective self-defense has also been criticized as not really self-defense, but defense of another state. Um, and so there has been criticism of this idea of collective self-defense because it's basically the means of defense to come to the aid of those who cannot defend themselves. And it's been criticized on one hand as a not really a self-defense, but also has been seen as a demonstration of international solidarity against the use of force in international law. Now, the ICJ in the important Nicaragua case, which has come up again and again, stated that there's three elements which must exist before collective self-defense can be invoked by a state. And so these were envisioned by the court to operate as mechanisms to prevent the abuse of the right. So, firstly, the court noted that reliance on collective self-defense does not remove the need for the state concerned to be a victim of an armed attack, as this was the fundamental condition required for the exercise of the right of collective self-defense. Secondly, the victim state must declare that it has been the victim of an armed attack. And so the court said it is to be expected that the state for whose benefit this right of collective self-defense is used will have declared itself to be the victim of an armed attack. That just means that another state can't just then invoke the right of collective self-defense on the basis of its own assessment, even if a victim state hasn't asked for one. And then the third principle, which arguably the most important, is that the victim state must expressly request the assistance of the state claiming to act in collective self-defense. But this has also been subject to criticism as well, which won't get into huge amounts of detail here. But I mean, these three principles are still quite important ones. And one of the issues about this, which is probably maybe worth speaking about a little bit, is especially because in terms of the contemporaneous relevance to the last decade or so, is that if there is some kind of gravity required for this first principle that the ICJ elaborated in the Nicaragua case, that there has to be some kind of gravity of the attacks before constituting an armed attack, it's arguable that the actions of the so-called Islamic State in Iraq and through its operations against Iraq, which included the seizure of cities, towns, and oil plants, had crossed this threshold. But it was notable that Iraq did not claim, as the ICJ appeared to require in the case, that it had been the victim of an armed attack. And the defending states helping Iraq also didn't make the claim that Iraq had been the victim of such an attack. But it was clear that there was some kind of request of assistance from Iraq as well. And then when the United States invoked the right of collective self-defense upon initiating its military actions, it stated that the government of Iraq had asked the United States-led international efforts to strike Islamic State sites and military strongholds in Syria in order to end the continuing attacks on Iraq. And then the other states acting in collective self-defense were similarly explicit about the fact that they were acting upon the basis of Iraq's request for assistance. So this kind of demonstrates that this isn't a strict requirement to have these three elements here, and especially arguably maybe not the first one, or some kind of threshold to be met for the armed attack to be sufficient to then require this collective self-defense. But this is also a prominent argument still in international law, this idea of collective self-defense. The collective self-defense is a prominent commitment in a lot of bilateral and multilateral treaties. For instance, the North Atlantic Treaty on Collective Self-Defense has been seen as an important commitment by the NATO states, especially with the invasion of Russia into Ukraine, where there has been increasing or a perceived threat among the NATO members that they might have to initiate collective self-defense. even in that conflict itself, there was claims of collective self defense, which provided a backdrop to Russia's illegal invasion in 2022. And in this way, Russian President Vladimir Putin claimed that uh, they were acting in not only self-defense, but also a claim of collective self-defense. Um, because just a day or two earlier, Russia had recognized the two separatist-leaning regions in the Donbass of Donetsk and Luhansk as the sovereign states of the Donetsk People's Republic and the Luhansk People's Republic, which was widely condemned as a violation of international law. And then these new states immediately subsequently signed treaties of friendship and mutual assistance with Russia, and then requested its military aid and requested protection. And then Putin justified the invasion of Ukraine as a measure of collective self-defense, again, which was criticized roundly amongst the world and doesn't really have any legal standing in international law opinion. So there, we'll now talk about the collective security of that authorized by the Security Council. So the powers of the Security Council to resort to enforcement measures, including the use of force, are found within Chapter 7, as we mentioned, of the UN Charter. And the first provision, Article 39, provides that the Security Council shall determine the existence of any threat to the peace, breach of the peace, or act of aggression, and shall make recommendations or decide what measures to be taken in accordance with Article 41 and 42 to restore international peace and security. And this provision of 39 has been seen as like the gateway to the enforcement powers of the Council. But before it can actually access these powers, it needs to determine the existence of a threat to the peace, breach of the peace, or act of aggression. So, it's been said that there's a direct relationship between the concept of or the concept of the threat of force under Article 2, subsection 4 of the UN Charter, and the concept of the threat to peace under this Article 39. So the Security Council's competence is defined at its limits by Article 2, subsection 4, to determine that a situation was a threat to the peace when it was not a threat, when it was not a threat of force. So it has to be a threat of force to be a threat of peace. But the Charter doesn't like directly make this link, and it's just kind of presumed that a precise link was intended between these two. But these triggers for Chapter 7 aren't always concomitant with Article 2, subsection 4, because the concerns of the Security Council are more broadly with world peace and security, not just the more specific threat of armed force or the actual use of armed force. And the Council has previously treated as threats to the peace issues such as proliferation of armaments, threats of terrorism, the disintegration of failed and failing states, massive flows of refugees, and also violations of human rights, which are all kind of outside the use of force of Article 2, subsection 4. And the Security Council has determined the existence of a breach of the peace or act of aggression on not many occasions. And when it has done so, it hasn't really given any clear meaning to be attached to its determination. So it determined a breach of the peace, for example, in the context of North Korea's invasion of South Korea in 1950, Argentina's invasion of the Falkland Islands in 1982, and also Iraq's invasion of Kuwait, which involved the invasion and occupation by one state of the territory of another. And it's also made, Security Council has made a determination that an act of aggression has occurred also in a number of occasions, such as Rhodesia's actions against Zambia, South Africa's actions against Angola, and also Israel's actions against Tunisia, mostly in the mid 70s to mid 80s. So, in addition to recommendations that the council can make under 39 and provincial measures that it can take under Article 40 to prevent an aggravation of the situation, the enforcement measures of the Security Council are found within Chapter 7 of the Charter. So it has the power under Article 41 to resort to non-enforceable measures, and this can be like interruption of economic relations, blocking rail, air, sea, postal, telegraphic, radio, and other means of communication, severance of diplomatic relations as well. However, should the Security Council decide that these measures would be approved to be inadequate, it can then, under Article 42, take such action by air, sea, or land forces as may be necessary to maintain or restore international peace and security. So it can actually like have some kind of more physical enforcement measures. But it's been said that these powers are exceedingly wide and basically unlimited. But while its discretion in determining the existence of the conditions necessary to open the gateway to forcible powers is wide, they're not unlimited. And there are limits both within the UN Charter and external to it imposed upon the breadth and scope of the Council's powers. So first, neither the text nor the spirit of the Charter conceives this of the Security Council as unbounded by law. And so the Security Council's powers, even though they're broad, are still grounded in the Charter, through which they've been delegated to it by states. So it has to act in accordance with the purposes and principles of the United Nations under Article 24, subsection 2. And the Council's actions are subject to peremptory norms of international law, which is also really important as well. And the decisions and actions of the Security Council must satisfy the requirements of necessity and proportionality. And finally, a decision to employ forcible measures, the Security Council then will become a party to an armed conflict. And so then international humanitarian law, as a branch of international law, will then encompass it, even though it doesn't make specific provision for the Security Council as a subject. Per se, but the UN Security Secretary General has previously said that Security Council would be responsible for violations of international humanitarian law, and especially the United Nations are responsible for those violations by its peacekeepers in peacekeeping operations. Now, collective action under Chapter 8 is also an important part. The UN Charter did not attempt to establish a system of collective security which begins and ends with the UN, and especially not with the Security Council. And so regional organizations are given attention in Chapter 8 of the Charter and are seen as essential elements too. Article 52, subsection 1 of the Charter talks about the existence of regional arrangements to help with peace and welfare of the global community. So there's a recognition of various organizations operating within the realms of collective security, but it raises issues about competences allocated between them and the UN. There's an argument that again, when there's conflicts between regional organizations and the UN more broadly, we should start with the text of the organizations concerned, look at the provisions of like the UN Charter, for example, and the Charter of the regional organizations. There is scholarly work that goes into this in a lot more detail, but it's not super crucial for our purpose outside to know that there's this part that exists. Now, with time, I won't go into this in a huge amount of detail, but may just briefly skim through this, as again, it's spoken about at length in your textbook. But the responsibility to protect is also an important measure, and this was kind of in response to the atrocities that occurred in Rwanda in 1994, where approximately 1 million Rwandans lost their lives over a period of just 3 months, which shocked the entire world and raised questions on the willingness and ability of the UN and the international community to actually intervene when necessary, and especially when a genocide is ongoing. And a major failure to intervene and take necessary action was also a multitude of reasons, but was also arguably the preceding failure of the UN to quell regional unrest, which then led to subsequent withdrawal of many diplomatic missions in the region. But it wasn't long after the horrors of Rwanda that the notion of sovereignty as a responsibility, as then just compared as just a power or a right, began to emerge. But it wasn't really until after the unauthorized NATO intervention in Kosovo in 1999 that there was some kind of reshaping of sovereignty to, was more prominent, which put question marks over whether sovereignty was inhibiting the protection of those at grave risk of harm. And this is where the conception of the responsibility to protect then emerged in the early 2000s, which the central idea being that sovereign states have a responsibility to protect their own citizens from catastrophe. And so this was given a lot of attention throughout the early 2000s as a potentially new emerging principle. But there's been a lot of uncertainty exactly about who had responsibility to protect, what circumstances it could require action or be relied upon in justification for it. And the emphasis that the doctrine put on the prime responsibility of states to protect those within their borders was not the controversial part of the doctrine, but the major controversy focused on the meaning of the secondary responsibility on the international community. Like, was this only exercised by the UN through the Security Council? Could regional organizations do it? Or was there some kind of state that would come in? So this was a very controversial doctrine and hasn't been implemented really much in practical forms since. Now, I know that's been quite a long time, team, so I'm going to leave it there. There was a huge amount of content to get through. Now, tutorials this week, I do have an exciting activity, which I think everyone will enjoy. So I hope to see you there. Thank you so much for engaging with the content as well. And I hope the submissions for your assignment too went well. Just email me if you have any questions at all too. Thank you very much, team.